Continuing. On October 25th, 2023, a week after improperly announcing the grand jury date to the public, Morrissey and Lewis, the special prosecutors here, served a target notice on Baldwin that omitted the standard 48-hour deadline for the target to provide a grand jury alert letter, even though they simultaneously acknowledged never having seen that provision omitted before. Does this omission matter, folks? Only if it results in harm. Did it result in harm here, or did they have months to prepare and submit an alert letter that was, in fact, presented to the grand jury? The answer is the latter. After admitting that she had eliminated the standard provision from the target letter, Morrissey stated she was nonetheless happy to work with Baldwin's counsel in this regard and will fully consider any requests made by Baldwin's counsel, which she did. Further, although Morrissey said she intended to ask the grand jury judge to shorten the deadline for Baldwin to submit an alert letter from November 14th to November 10th, just a few weeks after Baldwin received the target notice. Remember, now they're saying that we only had a few weeks to respond, but previously they were complaining this is hanging over his head for 2.5 years. Which is it? Morrissey also asked whether that was agreeable and to let me know your thoughts. Does that mean that however they respond is binding on Morrissey? If they say, no, we want 5 years to prepare our alert letter, does Morrissey have to concede that? No, of course not. She's willing to listen and consider. Continuing, Baldwin responded, his lawyers responded, that at a minimum, he should receive the full time to submit an alert letter that he's entitled to under New Mexico law, especially given the volume of evidence and number of witnesses involved in this case. In addition, Baldwin stated that the grand jury date should be adjourned to allow the state sufficient time to review the voluminous alert letter we will be submitting. In other words, we are going to be sending you an alert letter that's so full of hot garbage that, believe me, you're going to need years to work through this thing. Voluminous. They're telling her it's going to be voluminous. Remember, there's four legal elements to this criminal prosecution. That's it, folks. Not 400. There's 4. And they're all supported by what happened in that church when Alec Baldwin fired that gun into Helena Hutchins. Continuing. In addition, Baldwin stated that the grand jury date should, voluminous letter will be submitting to ensure this process is done properly the first time around. When the defense says the first time, they mean never. We never want this to happen. We never want this to go before a grand jury. Baldwin's lawyers believe this to be a reasonable and fair approach. Well, that's controlling then, because a prosecuting attorney is required to alert the grand jury to all lawful, competent, and relevant evidence that disproves or reduces a charge or accusation or that makes an indictment unjustified, and that was within the knowledge, possession, or control of the prosecuting attorney. Yeah, that's true. But how much of what the defense wanted to submit in their alert letter was relevant evidence? Almost none of it. None of it. There is a significant volume of evidence in this case, and it doesn't say relevant evidence, and the consequences of any failure to present exculpatory evidence are severe. Baldwin's attorneys therefore asked Morrissey if she was willing to discuss a reasonable schedule for this process. Reasonable to who? To the defense. Although Morrissey expressed a willingness to work with Baldwin's counsel in this regard and discuss a schedule that was agreeable to Baldwin, Morrissey immediately rejected Baldwin's request and stated that Baldwin was not entitled to additional time to submit requests that certain evidence witnesses be presented to the grand jury, because she can see they're unjustly just dragging their heels. Morrissey also claimed that the state intended to treat Mr. Baldwin not differently than similarly situated defendants in New Mexico, even though she had just admitted that she'd never seen a target treated that way. Now they're talking again about this 48-hour notice thing that caused no harm. In fact, the special prosecutors already had treated Baldwin differently. On the same day they served the target notice on Baldwin, they also served the target notice on Hannah Gutierrez-Reed. But the target notice Morrissey served on Gutierrez-Reed contained the 48-hour deadline that Morrissey had intentionally deleted from Baldwin's letter, which therefore gave Gutierrez-Reed 4 days more than Baldwin to submit exculpatory material. 2.5 years ago, this event happened, folks. Does anybody need 4 additional days to submit exculpatory material? Their client's already been indicted by a grand jury once, facing the same criminal charge. Anybody think the exculpatory material, if any, is ambiguous or hard to find? On October 30th, 2023, the state filed an expedited motion to shorten Baldwin's time to present exculpatory evidence by 4 days. In its motion, the state falsely, more misconduct alleged against Morrissey, represented that it had provided Baldwin continuous access to its investigative files since April 2023, when the previous prosecution was dismissed, and argued that in any event, Baldwin didn't need the full statutory period to provide exculpatory evidence because he was already well aware of all possible directly exculpatory evidence today. And that's true, as a matter of fact. It just doesn't include the quote unquote exculpatory evidence the defense thinks is exculpatory, but which, as a technical legal matter, is irrelevant.